Hi, I'm Philippa McDonald, and welcome to a special series of interviews brought to you by Compass on enduring powers of attorney. John Chesterman, Public Advocate for Queensland. What is an enduring power of attorney and how do they work?
An enduring power of attorney is a mechanism by which a person can appoint someone to make decisions for them in the event that they're not able to make their own decisions. So it's a signed document which endures beyond the loss of a person's capacity to make their own decisions. We can make enduring powers of attorney to appoint people to make decisions in a range of areas, including things like where the person lives, what medical treatment they receive, and decisions about their finances. And the financial enduring power of attorney, which we're talking about today, enables a person to make financial decisions on another person's behalf.
Well, what's the difference between a good enduring power of attorney and a bad one?
A good enduring power of attorney is one where the person or the people you appoint to make decisions on your behalf are people you trust, who will check in with you as to what your views are, and who know you well, so that they know the kinds of decisions that you would like to make in the event that you're not able to make those decisions. It's important to think about ways in which you can protect yourself, because bear in mind, enduring powers of attorney are instruments that may only become enlivened or activated many years after you complete them. So there are some protections you can build in. One protection that's often used is that people will appoint more than one attorney. So you can appoint some jurisdictions, more than two attorneys, who you can require to make decisions jointly, or you can say severally, so either can make decisions on your behalf, but that ensures that another set of eyes are on what is happening. You can build in specifications into the instrument itself about a requirement for instance, for an accountant to go through and audit the expenses that have been made on your behalf. There are other protections you can build in too, in terms of advising others around you who are important to you about who you're appointing and why you're appointing them, and what role you want them to have in observing what's going on. You can even require attorneys to give information regularly to other people who are around you. So there are all sorts of ways to protect yourself when you complete an enduring power of attorney. So that's a good one.
What about a bad one?
A bad one sees any of those elements missing. The prime example of a bad one is where an attorney or attorneys are appointed who the principal doesn't actually trust or doesn't have reason to trust, and who then see the enduring power of attorney as the opportunity for them to simply spend your money how they see fit. And that can see bad behaviour which ranges from one extreme, from making decisions that you wouldn't have made, right through to simple theft, where the money is used for their own purposes. And sometimes people can have bizarre justifications for the use of the principal's money. For instance, they might occasionally drive the principal to a doctor's appointment and somehow justify spending the principal's money on buying themselves a new car. We've seen that kind of example occur in the past. But the main reason why an enduring power of attorney would be a bad one is because the people who are appointed to make decisions on your behalf can't be trusted to do so.
There is a perception that creating an enduring power of attorney is an expensive exercise. Is that true? And are there inexpensive ways of getting this done?
It doesn't have to be expensive. There are ways in which you can in fact do this for free with publicly available information. The threshold requirement though is you have to get these documents witnessed. My advice to people is, if they can afford to get a lawyer to assist them to do this, that's probably worthwhile, because a lawyer can answer all sorts of questions the person may have, and a lawyer can also help to draft particular clauses that the person might want in their enduring power of attorney. And a simple enduring power of attorney can be bought for, or a lawyer can be engaged for a bit over $200 to help them complete a simple enduring power of attorney. So my advice is, if you can afford a lawyer to assist you to do this, it's probably worthwhile, but check what the cost is in advance of doing that.
What kind of responsibilities do lawyers have in terms of creating an enduring power of attorney?
Well, lawyers have the responsibility to follow the instructions of the principal, the person executing the document. They'll also have responsibility to inquire about what is it that the principal wants to happen in the event that they're not able to make their own decisions. Who do they want involved in their life, and what sort of powers do they want to give that person or those people? They're the kinds of things that the lawyer will be required to engage with the principal in getting answers to those questions.
Why do enduring powers of attorney vary from state to state and territories?
Well, that's a story of federalism in Australia. This area of law, like so many others, is the responsibility of the states and territories, and all states and territories have their own laws around enduring powers of attorney, and they've all developed at different times. There's an interesting trend that's going on in terms of the reform of enduring powers of attorney laws, which is increasingly seeing the states and territories, when they make changes, they're seeing those changes require attorneys, for instance, to make decisions that the person themselves would have made. That's a bit of a change from just making decisions that the attorney thinks is in the best interests of the principal. And there's some other changes that are occurring, but it really is a story of federalism in Australia. We have different jurisdictions have needed to weigh up two things. On the one hand, we want enduring powers of attorney to be relatively easy to complete so that people can complete them. On the other hand, we want safeguards in place to protect principals from nefarious acts of attorneys, or indeed from negligence by attorneys. So, for instance, in Queensland, there's a requirement that there be one witness to an enduring power of attorney. In Victoria, there's a requirement that there be two. So those two jurisdictions have just wrestled with those questions differently and coming up with their answer.
What is the role of an attorney, and who should you have as your attorney?
The role of the attorney is to make decisions that are in the interests of the principal, to avoid conflicts of interest, to keep their finances, when we're talking about a financial enduring power of attorney, to keep their finances separate, and to avoid exposing confidential information or making public confidential information. So they're the key responsibilities of an attorney. And who you should choose is fairly simply answered by identifying the person or the people you would most trust to make decisions on your behalf. That can be one person, it could be a couple of people, and you can appoint people in alternate, so that, for instance, I could appoint you and I could appoint someone else as my alternate attorney if you weren't able to act. But the person you should appoint, or the people you should appoint, are the ones you trust to make decisions on your behalf. It's important not to take considerations into play that aren't relevant, and a common one that people will factor in will be along the lines of, my eldest son will be disappointed if I don't appoint him as my attorney. That's not a consideration that I would advise you to take into account. The people you want to play the role are the ones you trust to make decisions on your behalf, not the people who are going to be disappointed if they're not appointed.
Why?
For a start, the enduring power of attorney can see considerable power placed in the hands of the attorney. They can, with a financial enduring power of attorney, for instance, sell your house. You want to be sure that the person you appoint is someone you trust will make decisions that accord with what you want to happen or would have wanted to happen. It's a big, heavy responsibility. The other thing I say is, if the person is going to be very disappointed that they're not appointed, they probably wouldn't be a good choice anyhow.
Why?
Because they may have expectations that aren't in accord with the purpose behind an enduring power of attorney.
They might think that they could benefit by the arrangement.
That's the risk. And even if it's not something that they consider at the moment of appointment, bear in mind that enduring powers of attorney can have a long shelf life. So I can create one now, execute one today, that may not be activated for 20 years if I specify in my enduring power of attorney that's only activated should I lose my ability to make my own decisions. So that's a long time in advance, and things could happen in the life of the attorney that make that possibility more real down the track than it is now.
What happens when an attorney breaches their responsibilities?
Well, a number of things can happen. For a start, I would say that's grounds for immediately revoking the enduring power of attorney to the extent that that person has been appointed. If you don't have the power or the capacity any longer to revoke an enduring power of attorney, the enduring power of attorney can be effectively revoked by the state or territory civil and administrative tribunal on the basis that the attorney has breached duties. There are also other potential ramifications for an attorney breaching their duties. They may have committed a crime, so this could become a policing matter if they've effectively stolen money from you. They may also, depending on the jurisdiction, be liable to compensate you for loss that you and your state have incurred as a result of their breach of duties. So there can be a number of ramifications.
Walk us through what a breach of a power of attorney can look like.
Well, a breach of a power of attorney can be anything from, at one kind of light extreme, the attorney not being interested in what it is that the principal actually wants to happen with their money when they're making decisions. That's technically going to be a breach of an enduring power of attorney in most jurisdictions. At the other extreme, we can have simple theft, where a person uses the document to withdraw sums of money which they take for their own use. And that's clearly a crime as well, but it's another example of a breach of duty by an attorney.
Tell us about capacity from a legal perspective. Who decides if you have capacity, and is it clear?
Capacity is a legal question or legal concept by which we seek to make sure that someone is only responsible for the actions that it's reasonable to hold them responsible for. Capacity is relevant for enduring powers of attorney for two reasons. Firstly, you need to have capacity to sign an enduring power of attorney, and I'll talk in a minute about what capacity means. Capacity is also relevant with enduring powers of attorney because often an enduring power of attorney will only become activated if a person loses the capacity to make their own decisions. Now, with financial enduring powers of attorney, you can choose to have the enduring power of attorney active immediately or on the loss of capacity to make particular decisions. I put the Northern Territory at one removed from that. They have a particular requirement. How we assess capacity. Capacity in the end is a legal test and it is informed by medical opinion, but there's now a pretty standard four-prong test of capacity, which means that a person understands the decision they're making, they can retain information relevant to the decision, they can use or weigh up competing information relevant to the decision, and they can communicate that decision in some way. It doesn't have to be verbal. So that's the test of capacity. Ultimately, when push comes to shove, it is the State and Territory Civil and Administrative Tribunal which is the umpire about whether a person does or does not have capacity. It's a complex topic because we increasingly see capacity as decision specific, which means that you might have capacity to make one particular decision, a simple financial transaction, but you might not have capacity to make a more complex decision. So capacity is decision specific. This causes some difficulty with the operation of enduring powers of attorney, which like to imagine a bright line of having and not having capacity, but that's a complexity with which we have to live.
And how do you navigate it?
With great care, and I always say, when an attorney is, for instance, seeking to exercise power under an enduring power of attorney, and there is some question about whether the principal does or does not have capacity, and let's imagine the enduring power of attorney is only active on the person's incapacity. What I advise the attorney in that situation is to keep checking in and making sure any decision they make on behalf of the principal accords with what the principal wants. Then there's no problem because you're effectively making the same decision.
It seems like some attorneys can convince doctors and lawyers that a person doesn't have capacity, so they can activate the enduring power of attorney. How do you defend yourself?
The first point I'd make in response to that question is to say you want to appoint a person or people you trust and from whom you don't need to defend yourself. Having said that, there are ways in which a person can build in safeguards to prevent that situation from occurring. For instance, you can specify in the document that you want several medical experts to announce or agree that you no longer have the ability to make your own decisions before this particular instrument becomes active. You can, for instance, say you want a trusted GP to come to that determination before the instrument becomes active. I would caution people, though, to make sure that the enduring power of attorney is workable. So, for instance, if you specify a particular GP you want to, you say has to say, I've no longer got capacity to make my own decisions, you want to make sure that GP is going to be around when questioned on this topic, because if they're not, suddenly the instrument would become void. So you want to be a bit careful in how you craft that. But there are ways of guarding against that concern. There are other ways in which you can safeguard yourself. In a formal sense, you can include in the document monitors. So people who you say, if there's a significant financial transaction that's made, I want my attorney to tell these people that this transaction's being made. And then those people need to be told if they have any concerns, they might raise that with the attorney, or indeed raise a question before the civil and administrative tribunal in your state or territory. You can have informal mechanisms too. So you can say to some friends around you that in the event that this becomes active, I want you to be talking to the attorney about what's happening, and I want you, my attorney, to be talking to my friends about what's happening. That's an informal way of making sure there are more than one set of eyes on you and your finances.
How do you go about changing an enduring power of attorney?
So at any stage you can revoke your enduring power of attorney if you're not happy with what's happening, so long as you have the capacity to make that decision and do that revocation, and you can always make a new one if you want to appoint somebody else. Again, as long as you've got the capacity to do that. There are some situations where an enduring power of attorney will become automatically revoked. For instance, if you appoint one attorney and that attorney is no longer able to make their own decisions or dies, or indeed you die, your enduring power of attorney becomes revoked, so it stops working at that stage. Some jurisdictions also have particular revocation requirements in relation to if you marry or enter a civil relationship.
What's your advice about changing enduring powers of attorney and also updating them?
So I recommend people consider any instrument that they've executed every couple of years, make sure it still accords with what they want to happen. If you're not happy with it, change it. Because if you've got an inkling that it's not right for you, I do recommend you change it while you have the ability to do so, and think about revoking and creating a new one. But trust your instincts is what I would say.
Thank you. And in your role, what would you say to people about the importance of enduring powers of attorney?
I think it's a very important thing for everyone to consider. My pitch to people is to say it is preferable for you to have one if there is someone in your life you can trust to make your decisions. I think it is preferable to have one. If there isn't someone in your life who you can trust to make your decisions, it's probably better not to have one, because enduring powers of attorney are important ways of guarding against abuse. They can also become instruments of abuse. So it's important to make sure anyone you appoint is someone you can trust. If there is someone in your life who you can trust, then I would urge you to consider completing an enduring power of attorney.
John Chesterman, thank you so much for joining Compass.info.
It's been a pleasure. Thank you for having me.